Hello, welcome to my channel. Today we are going to see Article 2 to 4 in our article series of Indian Constitution. So, first let us see about Article 2. It says admission or establishment of new states. Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. So, what does it says is it grants two powers to the Parliament. So, Parliament by law can admit into Union of India new states. That is, you can admit a foreign territory and make it as a new state, and to power to establish new states. Okay, you can make an existing territory into a state. So acquired territory, what do you mean by acquired territory? For this, Sikkim is a best example. Sikkim was acquired from the Chogyal dynasty in 1975 around. Okay, and then included in our territory. It was not in our territory. Okay, and we made it as a state. We made it as a state. So this is one of the important aspect. Existing territory, we can give example as Delhi. See, which is the union territory. In future, if you want to make it a state, then you can use article 2. That means the parliament will use the article 2 of the constitution. By law, it will make as a state. So what is the difference? You are making an existing state into a existing union territory into a state. Here you are acquiring some territory from the foreign and making it as a state. So that's the difference between acquired territory and existing territory. So this is about article 2. Let's go into article number 3. Article number 3, you will form a new states within the territory of the India. How? By altering the areas, altering the boundaries, you can change the name of the existing states. Okay. So this is, it has 5 classes, the A, B, C, D, E. It talks about how you will form a new state from within the territory. Okay. So I'm going to explain you here clearly. So we can do it by 3 ways. That is formation of new state. How? By separation. For this, the best example is Andhra Pradesh and Telangana. Before 2014, it was only one state, that was Andhra Pradesh. After we Parliament passed a law, okay, Parliament passed a law and created a boundary between Andhra Pradesh and Telangana, and Telangana was formed as a new state. What did we do here? Separated the existing state. Here, or we can do it by uniting two states. How? See, suppose I'm going to take some example. Here it is Odisha and here it is Chhattisgarh. I'm going to take this boundary out, okay, and make these two as a new state. Okay, this is just an example. Okay, and I'm going to make it as a new state. How it can be done? Parliament by law. Okay, this is uniting. So you can unite a state plus state. You can unite even a state plus union territory. Suppose it is Tamil Nadu, here it is Puducherry. You can unite both this and make a new state. Or there are other things also, like you can take a part of this Chhattisgarh and include in Odisha and make a new state. Okay, it is also there. And also part of state, you can unite with union territory and form a new state. Okay, clear? So this is how you'll form through separation and unity. And also you can alteration of the areas of the state. That means you can change the area. See, this is the area of Maharashtra. You can either reduce the area or you can increase the area. See, I am saying it can be done only through parliament by law. This you should keep in your mind. Okay, and then other thing is you can also change the boundaries of the states for formation of new state. Okay, and also names of the existing state can also be changed through this article 3 of the Indian Constitution. But can it be done by the, I said, parliament by law can only make these changes. Okay, that means parliament have the sole power? No, it can introduce such a bill in the parliament only with the prior recommendation of the president. This is very important because there are some provisions in the our Indian Constitution where this consent of the president is very important. Another example I can give you is money bill. Okay, and then and also president, if there is any dispute in the boundaries or something else, president will forward the bill to the concerned state legislature for its views, and it has to give its views within a specified period. If it is not giving any view in the specified period, it will be, the time period will expire and president will pass to separate the state or unite the state, anything else. And you must understand that views of the state legislature is not binding on the president. Okay, so whatever it is, like advisory or recommendatory, that's it. It is not binding. President can take his own decision. Okay, this is about all about article 3. So next let us go into article 4. Laws made under article 2 and 3 to provide for the amendment of the first and fourth schedules on supplemental, incidental, and consequential matters, any law referred to in Article 2 or 3 shall contain such provision for the amendment of the first schedule and fourth schedule as may be necessary to give effect to the provisions of the law, and may also contain such supplemental, incidental, and consequential provisions, including provision as to representation in Parliament and in the legislature or legislature of the states affected by such law, as Parliament may deem necessary. No such law as aforesaid shall be deemed to be an amendment of the Constitution for the purpose of Article 368. This is little complicated. I will explain you in a simple manner. Here, the Constitution itself declares that laws made for admission or establishment of new states, that is under Article 2. See here it talks about Article 2, and formation of new states and alteration of areas, boundaries, or names of the existing state. It is Article 3, are not to be considered amendments of the Constitution under Article 368. That means these laws can be passed by a ordinary legislative process through a simple majority. What does it say means? If Parliament is doing any law, okay, if Parliament is doing any law under Article 2 and 3 of the Indian Constitution, under 2 and 3 of the Indian Constitution, it is not considered as a constitutional amendment act under 368. Okay, under 368 it is considered as an ordinary legislative process. So why we are talking about constitutional amendment? Because this article and 2 and 3 will touch the first and fourth schedules of our Indian Constitution. It will make changes in this first and fourth schedule. That's why if this provision is not there means this will, whatever changes it is doing in Article 2 and 3, it will be considered as a Constitutional Amendment Act. Okay, but Article 4 gives the Parliament the power that it will be an ordinary legislative process and you can pass it through simple majority. Okay, here the Constitution gives the power to the Parliament to make it as an ordinary legislative process. Okay, this is all about Article 2 to 4. If you like the video, please like, share, and subscribe. Thank you.